That makes sense. All right. One note, David and Lexi are going to be partnering for this camp because you both are stranded partnerless. So be friends, be nice to each other. Okay. So we are going to start with this presentation, but I'm just curious who all listened to the Heller case. If you did not, it is okay. Okay, that's fine. We are going to talk about the Heller case. I'll give you a brief rundown before we start. But the thing that I noted earlier, which is that you need to speak up if you have a question, applies. I don't know if you've ever screen shared on Zoom, but like you can't click stuff, so you can't see the chat, and you can't even see raising hands. So if you have a question, like verbally express it. Thank you. Okay, let's get started. I need to get up other presentation. Nope, wrong one. Heller. Okay. Okay, so a brief rundown of what this case is about. The Heller case was a case that was decided, oh man, I don't even remember the year. Pretty sure it's in 2012. This is Heller. Let's check. Oh, 2008, JK. I was close. All right, it was decided in 2008, and it's a case that's really about whether the Second Amendment is an individual right, meaning that everyone possesses a protection for their firearms, or whether it's a collective right, depending on your service in the militia, meaning that you have to be part of the military in order to have this protectable right. And that's what this case is really driving at. The reason why I picked this case is a couple of reasons. The first is that it is one of the cases that's in the 2018 packet that we're using for this camp. And the second is I really like Clement. And so I want to make a couple notes about how Clement goes about his argumentation and his responses to judges' questioning. So I wanted to start by just asking, for those of you who have watched or listened, I guess, to this video, audio, what are your guys' thoughts on a couple of things? First, what do you guys think of not always answering with your honor? Because if you'll notice, like, the people that are there are not saying your honor after every question like they teach you to do in NCFCA. So people who have watched that case, or even people who haven't, like, what are your thoughts on not having to say your honor after every question? Good, bad, mixed?
I guess I was kind of mixed about it. I thought I was impressed that with what Clement did, because he used the judges' names mostly when answering their questions, and I thought that was really impressive. So I felt like for him it was totally fine, but I felt like with Dellinger, is that how you say it?
Dellinger, yeah.
Dellinger. Okay, I felt like for him, especially as he started to sound more defensive as like his time went on, I felt like it started sounding rude on his part.
Mm-hmm. Yeah, I agree with that. Anybody else? Caleb or the Dones who have watched this?
It was far more conversational than Moot Court in NCFCA comes out to be. It wasn't just, well, your honors, you decided in this case about this precedent that this happened, so you need to follow it. No, it was more of a history discussion of what the original intent of the Constitution was. They talked a lot about the grammar structure of the day and whether it was influenced in that ruling. So I feel like it was more of a history and grammar lesson and less of a formal court hearing that I would think of when I think Supreme Court. It sounds so up there and high and mighty, when in reality it sounded like a conversation. And Ava, you're absolutely right. I did notice that he started getting more defensive towards the end of it, and even at one point yelling at one of the justices, which was kind of rough.
Yeah, definitely. I thought, like, that's touching on that third question I have down there. What did you think of the field argument versus Moot Court? And one of the other reasons why I had you guys listen to a real case is because when we have Moot Court, we kind of think of it as like an academic exercise where it's completely divorced from what real advocacy is about. Because when you think about real advocacy and you're defending a position, it's not just about like winning the argument, it's about like finding truth. And that's why you'll see that the Moot Court discussions versus like the real Supreme Court discussions, in the Supreme Court, they have much more conversational styles because they're not super adamant about like, I have to win this argument, I have to win this position. You'll hear some of that from Dellinger, but like overall, it seems much more of a truth-seeking exercise. And so it makes both of the, at least for Clement, it makes him seem a lot less aggressive and like super strict about everything. The one note that I have at the top here is just talking about knowing your cases better than your opponents and your judge. Specifically with this Heller case, pro tip for your rounds on Friday, the Heller case is a case that has nothing to do with immigration. And so while the packet makes it seem like it's about immigration, have any of you guys done this case? Okay, so Lex is the only one. The Heller case has nothing to do with immigration. If you read through the actual packet, what it's trying to do is say, since Heller talked about the Second Amendment and was saying that it applies to all citizens, it was referring to citizens. But the question in Heller wasn't actually about immigrants. It was just saying, is it an individual or a collective right? And understanding something like that is going to be massively important. It's going to be crucial for you to be able to win your future moot rounds. That's going to be your one advantage, because in the Supreme Court, dude, those justices are brilliant. Like, they are some of the most brilliant minds in the entire country. If you listen to them, like, just obliterate their the council's arguments, it's just mad impressive. Your one advantage over the poor counselors who have to appear before the Supreme Court is that your justices probably know less than you, but they'll only know less than you if you do your homework, do your research, figure out what the cases are really about, and then you can be in a position of actually knowing more than the justices. That'll help you a lot. Okay, let's get into a couple of specifics. We can start by talking about Dellinger's introduction. Hold on, I need to do one thing here. I need to move you guys. Okay. So we can start by talking about Dellinger's introduction. The first thing that I liked was this good morning phrase that he uses here. It's very unique because in moot court, we always are like, Mr. Chief Justice and may it please the court. But like this good morning thing, it's kind of a small thing, but it shows the justice that like, while this is a formal setting, you're still talking to the justice like they're a person, because they are. I also like this phrase, what is at issue this morning? It's a really great way to succinctly tell the justices, well, what is at issue this morning? Instead of going a roundabout way and making these grandiose claims about what the Second Amendment is, what the purpose of the Second Amendment is, and then going through this whole rundown of the facts of the record, you could simply state like, what's at issue this morning is, and in Dellinger's words, what's the scope of the Second Amendment? What's at issue this morning is the scope of the Second Amendment. That's all you need to figure out. Sorry, I need to change this thing. Okay. I'm gonna move this. I need to see your faces while I'm doing this. Okay, the third thing that I liked was this get to the crux fast. He is immediately jumping to what is happening and what they're gonna be discussing during this whole hearing. He's immediately getting to the crux is the Second Amendment and how big the Second Amendment is. Get to that crux fast. And then the last thing is, sheesh, I can't even see that. Oh, okay. Yeah, what I said earlier, which is avoid clunky, grandiose intros. It's a very simple introduction that he gives. You don't have to go on long and long and long about it. It doesn't really matter what the conventions are. You just have to. I'm sorry, guys. I need to move this talking screen because it's distracting me. Okay. If I make this smaller. Okay, that's fine. All right, using the yet but phrase. So we have here Dellinger, who's telling the Chief Justice that the phrase the people and the phrase the militia are the same thing. Roberts, as he should, is like, well, hold on a second, that cuts against you. If you're saying the militia is the people, then that means that everybody has a right to the Second Amendment. Well, and Dellinger uses this yes, but phrase, and he doesn't explicitly use the word but, which is kind of nice, but he has this thing where he says, yes, I do believe it includes all the people, but what defines the amendment is the scope and the nature of the right that all the people have. And so while it applies to all the people who are in the militia, he's saying there's a defining scope where only a certain quantification of those people can actually have this right. And so using this yet but phrase is good for a couple of reasons. The first thing is that you're agreeing with his justice. He could have come out straight and said, it's not talking about all the people, it's talking about the militia. But he uses this yes but phrase to tell the justice that he hears the justice, that he agrees with the justice, and yet he still has a position to stand on. So using that yes but phrase is entirely crucial to having good responses to justice's questions. Okay, this next one is kind of interesting. So Dellinger this whole time has been talking about how there is no individual Second Amendment right. The Second Amendment is only a collective right. And then the justices start asking him about William Blackstone. Blackstone says that there's a right to self-defense. And the justices are like, well, if there's a right to self-defense, then what do you have to say about that? And Dellinger responds by saying, well, yes, Blackstone says that there's a right to self-defense, but he has this qualifier where he's like, it's only the weapons that are allowed by law. What has Dellinger done here that's bad? So his original argument is that there's no such thing as a protectable Second Amendment right. And then he goes on this thing to respond to Blackstone by saying, well, Blackstone said that you can have reasonable regulations. So what has Dellinger done wrong?
He's gone from there is no case in which this would be okay to, well, it might be okay in certain instances. He's contradicting himself in a big way.
Exactly. So, as a good justice should, Roberts destroys him. Well, that may be true, but that concedes your main point here, that there's an individual right, and gets to a separate question. And that's exactly the problem with what Dellinger is saying. So what's the impact of this on moot court? Don't move on to the arguendo clause too fast. Arguendo is when you say, for the sake of argument, we're going to assume that this is true and move on. And we like to use this in moot court, and we like to say, well, there is no Second Amendment right, but if there were, this is reasonable. Don't move on to that clause until you have a clear break and you say, for the sake of argument. Dellinger never made that clear break. He moved on to the arguendo clause too fast, and that's why he got slammed by Roberts. Okay, speaking of arguendo, I actually liked that Dellinger didn't have an explicit, he wasn't planning on talking about arguendo. His entire case was predicated upon the fact that there is no Second Amendment right, and that's all he was going to say. He says, if we assume for a moment arguendo, but this is just kind of an audible. He wasn't planning on it, as you can tell by his introduction. I actually kind of like this, and I think that you might consider using this. So if we apply it to, for example, the Fifth Amendment, and we say there is no such thing as Maria Alvarez being protected by the Fifth Amendment, you don't even need to go into your arguendo clause. Well, if she were protected, she still doesn't deserve the right to a release hearing. You don't necessarily need to move into that. You could simply have a different argument, and here I'm going to lay this out for you. Standard, the petitioner fails the standard, and that's all you need to prove. The Fifth Amendment only applies to people in the Republic. Alvarez is not in the Republic. Therefore, the Fifth Amendment doesn't apply to her, and that's all you need to cover. You don't even need to go into this arguendo clause about, well, if it did, then maybe she would still not be deserving a release hearing. The reason why that's a strong argument is because if you don't use your arguendo clause, if you use your arguendo clause, you're actually weakening your first argument. Because number one, it's the last thing a justice hears. The last thing the justice hears is well, I'll give you that. I'll concede it for a second. That's not a good thing. That's not a good look. And then the second thing is that it makes it sound like you're not confident in your first argument. You're like, I might lose on my first argument, so I might as well have a second argument just in case. So it's not horrible to have an arguendo clause. There's nothing wrong with it. But you can consider instead having that simple two-part argument. Fifth Amendment only protects those in the jurisdiction, petitioners not in the jurisdiction, and then have lots of proof for those two arguments, and that's all you need. Does that make sense to everybody? Okay. let's move on to my favorite person, General Paul Clement. What a good guy. I really like his intro, and he immediately has a completely different tone to Dellinger. Probably like I've listened to a couple cases, and Clement has the best demeanor in front of the Supreme Court. One, it's very professional, not like dragging on and slow. It's happy, it's upbeat, and yet there's clearly a seriousness to his tone. He's not taking it lightly, even though he does have a more happy and upbeat tone. Obviously, he also starts with his thesis statement here, very, very short. So whereas in moot court, we say like, we now request 4 minutes for rebuttal, and then we go on this thing about like, here's the facts of the record, and here's why the Fourth Amendment is important, and then here's how that all fits together. He just gets straight to the point. The Second Amendment is an individual right that doesn't depend on service in the militia. That's all he needs to say. He moves on. Good for Clement. Okay, now a couple of things that I really liked from his responding to questions thing. Stevens asked him, do you think that the amendment would have the same meaning if it had omitted the introductory clause referring to the militia? And just to clarify for the people who haven't listened to this case, the Second Amendment has two parts to it. It talks about the right of the people to bear arms, but it first begins with this preamble, this prefatory clause, where it talks about because of the necessary, the security of a free state, right? So there's the prefatory clause and then the operative clause. The introductory clause and the operative clause. So Stevens is asking, would the Second Amendment have the same meaning without that first clause? And Clement doesn't just say no or yes. He says, I don't think so. Really, really, really good. Because it shows, again, he's listening to the justice. He's not being extreme with his answers. And that's really persuasive to the judge. He also says, we don't take the position that. And I like that phrasing as well. He's showing the justice that he's reasonable. He's saying, we don't take this position that like the preamble has no role. We just think that it has a small role is basically what he's saying. And so you can apply that to any moot court case that you're dealing with, right? If a justice is asking you, so you're saying that Garcia is protected by the Second Amendment, even though this court said illegal immigrants can't have Second Amendment rights, what you would say is, we don't take the position that illegal immigrants should have Second Amendment rights. But we do take the position that because Garcia is a non-citizen, he's not even classified as an illegal immigrant. And that's reasonable because you're listening to the justice and you're showing the justice that you're not taking an extreme position. So I really like that phrasing as well. And one of my other favorite phrases is, we would point to this court's decision. Really, really good. You can shut down the justice with case law, with precedents. We would point to this court's decision as in Miller as an example of where the preamble can play a role. Use that phrasing a lot. We would point to this court's decision. It's a really good response to justice's questions. In general, you should have a lot in your back pocket of stuff where you're like, this is a good response to start an answer to a justice's question. And so one of those is like, we would point to this court's decision in Miller. Okay, responding to questions part 2. Okay, I really like this phrase too. Paul Clement says, I suppose it probably does define two rights that are closely related. Instead of saying, yes, it defines two rights that are closely related, he says, I suppose. And it also has a lot to do with his tone. So Stevens is like, do you think that the right to keep and bear arms are two separate rights or one? Clement is like, that's a good question, without making it seem like he's dumb. Like he's not saying, I've never thought about that. That's kind of dumb. Because you'll notice as he says that phrasing, he's like, I suppose it probably does define two rights that are closely related. A very succinct, clear statement here. But he's using that, I suppose, to show the justice deference, that he's listening to the justice. And it makes the justice feel good about himself because he asked a really good question, right? And you always want to make your justices feel better about themselves because that will make them like you more. Justice Stevens then says, is there a right to keep and bear arms? So he asks a follow-up question. And Clement says, instead of saying yes, he says, I think that's the better view. Again, use that phrasing. I think that's the better view. So if the justice is like, so you're telling me that Garcia is supposed to be protected by the Second Amendment, even though he's not even a citizen? Instead of being like, I know this sounds weird, Justice, but yes. Or like, according to this court's decision in this, yes. Just say something like as simple as, I think that that's the better view. And you can then use, and I would point to this court's decision and whatever, but using this, I think that's the better view, makes you come across as reasonable, doesn't shut down the other opponent, and still makes a strong argument. I also like this. I think keep is a word that is somewhat of an embarrassment for the other side, because he's using that justice's question, even though it's a closed-ended question. It's like, okay, so you think that there's a right to keep and bear arms. He's using that question to show how his side is superior and how that's exactly proves my point, Justice Stevens. That's what he's saying. And another really, really, really good one. If you've done Moot before, I hope you have used this before. As Justice whatever pointed out, if a justice has been grilling your opponents on something, you want to point out that they grilled your opponents on something. Because Justice Scalia was just grilling Dellinger about this word keep. And so Clement capitalizes on this. He says, and as Justice Scalia was pointing out in questioning to opposing counsel, keep is the word that authorities use in statutes designated specifically to disarm individuals. So we have some really good phrases here, good takeaways from Clement. Make sure you use that phrase a lot, as Justice whatever pointed out, especially on big panels. Part 3. Ruth Bader Ginsburg, who sounds senile, but her questions are a little less senile. She talks about how it doesn't mean like keep all weapons. It just means keep some weapons, right? And Clement says, absolutely, Justice Ginsburg, which, as Ava pointed out, it's very impressive that Clement is speaking to all of these justices and using their last name. If you really want to, which I think is totally fine, you can ask justices' names before you start, write them down. That's what a lot of good moot court teams do. Write down the names of your justices so that you can refer to them by name. Make sure you get the pronunciation right, because it's really bad if you don't. If it's a tricky name, maybe don't use the pronunciation, like don't say it and just say Your Honor, that's fine. But I think that it's actually extra special for justices if you use their last name. The tone here is also really good. He's not flatlined, he's not bored. He says, absolutely, Justice Ginsburg. And I'll give you a clear example that proves your point. And he's using this to show he's reasonable. If you look at the grand scheme of this whole case, not every question is going to side with him, and he admits that. Because what he's saying here is, okay, not every weapon is protected by the Second Amendment. He's admitting that. But he doesn't feel the need to sound defensive, to act defensive. In fact, he's giving an example to Justice Ginsburg of how what she's saying is correct, how not all weapons are protected by the Second Amendment. And he feels that he can do that because he has enough confidence in his case that he's able to give examples to the justice of where the justice is correct. In shorter rounds, like in moot court, you don't have a lot of time to do that. But feel free to use that occasionally because it shows the justices that you're not just like hard line to your position, that you're actually seeking truth and not just winning the round, if that makes sense. Okay, I also like this phrasing. He has this yet, but, yet, oh man, I haven't said that right yet, have I? Yes, but phrase. That's what Clement is using here, and I like that. Also, this one, really, really, really good. Add this to your list of things that you can use when you're responding to questions. If Miller is going to continue to be law, because when you have like case law, what you're implying with this question is if you rule with the respondents, you're clearly overriding this law. It's no longer going to be law. So you could say, especially if Verdugo Riquidez is going to continue to be law, he has to be protected. Using phrasing like that is very subtle, but it's showing the justices that they really have to side with you. Okay, do you guys have any questions, any comments on what you thought? I'm going to stop screen sharing now about the case in general.
Do you think it's beneficial in rounds to be a little bit more like Dillinger was, more conversational with justices, or do you think it's better to be more serious and formal?
Ooh,
at least as far as NCFCA goes.
Right. I actually kind of thought Clement had a more conversational tone. Like Dellinger was.
Yeah, that's what I meant. Yeah, Clement.
Oh, yeah, okay.
Yeah.
I liked Clement's tone a lot because it shows that he didn't stake too much and put himself too much into the case. The thing with advocacy is that advocacy is supposed to be self-effacing, meaning like it's not focused on you. And so if you seem so invested into the round, it seems focused on you. If you have a happy, upbeat tone and you're like, absolutely, justice, whatever, that's exactly what I think. Or like, to give you an example of this, that sounds a lot more like it's not about you, it's about the facts, it's about what you're representing. And so I think that that absolutely is going to be a good idea for you in terms of advocacy. It's always better to err on the side of being more conversational and likable because that's always going to be more persuasive. Good question. Anybody else?
Yeah, sometimes when they were asked a question, they would like finish their sentence, particularly Dellinger. I still can't say that, but like I noticed sometimes like if he was at the end of a sentence, he would finish his sentence even though the judge was trying to start talking. Do you do that, or do you stop as soon as the judge starts?
No, that's a bad idea to do that. In moot court, as my moot court coach once told us, the justices are the gods and you are nothing. And so if you're speaking while the justices are speaking, then you are disrespecting the gods. So don't do that. Be very respectful. And if you are cut off in the middle of a sentence, then it's fine. Get cut off. But don't keep speaking. I did notice that, and I thought that was a little bit rude of Dellinger. He didn't have the best court manners, as some of you pointed out. And I think Clement had easily, like, in contrast, Clement was just phenomenal. Like, just the way he addressed justices, used their names, had a really good speaking tone, listened to their arguments and, like, agreed, and never seemed to get tripped up. I love Clement. Good guy, real good guy. Be like Clement. Any other questions? Also, if you have questions about, like, things you heard in the case or things about the case, ask them too.
So something that I noticed about Dellinger was kind of, well, when he first started speaking, I hadn't heard him for very long. I don't know if it was just me, probably. But he sounded, I don't know, it might have been just the tone of his voice, or I don't know how old he was, but he sounded out of breath and a little bit drunk to me. He was a little, like stumbling over his words just a little bit. And it was just hard to pay attention to when all I could think of was, how much did you have to drink last night? And then Clement, the one thing I didn't like about him was when he first started, justices were asking him a hypothetical. They said, if we let your side win, basically, if we give it to respondent in this case, what if this happened because of our decision? And instead of answering the hypothetical, he kind of dodged it and moved away from it, saying, you know, it's like, who was it that said, I think it was Reagan, who said, I find that I never get in trouble for not answering a hypothetical. It was almost like he moved away from the question entirely rather than answering it. And honestly, I prefer the hypotheticals because it's if this happens, this is a natural consequence, what would you do? And he kind of, I don't know if he was afraid of the question or honestly thought it didn't matter, but I didn't like the way he handled it.
Yeah, I'm reading through this again. I definitely, like, I didn't think he was that bad. To your point about Dellinger, he definitely did sound a little trippy, but I don't know if I call him drunk. But in general, don't be drunk, guys. Don't drink before your rounds. Just, I know you guys might be tempted by that kind of stuff, but stay away from the beer, the whiskey, and the vodka. Oh shoot, my mom's in the room. Okay, sorry. This was, okay. All right, so, any other questions? Sorry, I'm reading through this case because of Catherine's comment. Was that later on?
It might have been. It was one of the last comments I made on my paper. It may have been like minute 20 or like minute 19.
Okay. Yeah. Well, I think, yeah, I don't specifically remember that part with Clement, but Dellinger, yes. Okay. Well, barring any other questions, did you have anything else to add? Any observations that you had from the Heller case that you wanted to point out? Okay. Let's move back into the main session. We're going to watch, I guess, the tail end if we are lucky enough to catch the tail end of Intro to Moot. And I know some of you guys might still like to hear some of that stuff. Okay, so thanks, guys. You guys won't have well, let me check the schedule. Yes, so the next session is the case overview, which will be a main session. And then we'll be coming back to this experience track. You'll be with Hope Turner at 11 o'clock around. All right. Head back to the main session.